Fellow citizen, you are most welcome in another episode of the Union Executive in the series of our Constitution. Nature of the veto power. Generally speaking, the object of arming the executive with this power is to prevent hasty and ill-considered action by the legislature. But the necessity for such power is removed or at least lessened by the executive itself initiates and conducts legislation or is responsible for legislation. As under the parliamentary or cabinet system of government, as a matter of fact, though a theoretical power of veto is possessed by the Crown of England, it has never been used since the time of Queen Anne. Where, however, the executive and legislature are separate and independent from each other, the executive, not being itself responsible for the legislation, should properly have some control to prevent undesirable legislation. Thus, in the United States, the President's power of veto has been supported on various grounds, such as A. to enable the President to protect his own office from aggressive legislation, to prevent a particular legislation from being placed on the statute book which the President considers to be unconstitutional. For though the Supreme Court possesses the power to nullify a statute on the ground of unconstitutionality, it can exercise that power only in the case of clear violation of the Constitution, regardless of any question of policy, and only if a proper proceeding is brought before it after the statute comes into effect, to check legislation which he deems to be practically inexpedient or which he thinks does not represent the will of the American people. From the standpoint of effect on the legislation, executive vetoes have been classified as absolute, qualified, suspensive, and pocket vetoes. Absolute veto. The English Crown possesses the prerogative of absolute veto, and if it refuses assent to any bill, it cannot become law, notwithstanding any vote of Parliament. But this veto power of Crown has become obsolete since 1700, owing to the development of the cabinet system, under which all public legislation is initiated and conducted in the legislature by the cabinet, judged by practice and usage. Thus, there is at present no executive power of veto in England. Qualified veto. A veto is qualified when it can be overridden by an extraordinary majority of legislature, and bill can be enacted as law with such majority vote overriding the executive veto. The veto of the American president is of this class. When a bill is presented to the president, he may, if he does not assent to it, return the bill within 10 days with a statement of his objections to that branch of Congress in which it originated. Each house of Congress then reconsiders the bill, and if it is adopted again in each house by a 2/3 vote of the members present, the bill becomes a law, notwithstanding the absence of the president's signature. The qualified veto is then overridden, but if it fails to obtain that 2/3 majority, the veto stands and the bill fails to become a law. In the result, the qualified veto serves as a means to the executive to point out the defects of the legislation and to obtain a reconsideration by the legislature, but ultimately the extraordinary majority of the legislature prevails. The qualified veto is thus a useful device in the United States, where the executive has no power of control over the legislature. By prorogation, dissolution, or otherwise, Suspensive veto. A veto is suspensive when the executive veto can be overridden by the legislature by an ordinary majority. To this type belongs the veto power of French president if upon a reconsideration parliament passes the bill again by a simple majority, the president has no option but to promulgate it. Pocket veto. There is a fourth type of veto called the pocket veto, which is possessed by the American president. When a bill is presented to him, he may neither sign the bill nor return the bill for reconsideration within 10 days. He may simply let the bill lie on his desk until the 10 days limit has expired. But if in the meantime Congress has adjourned, that is before expiry period of 10 days from presentation of the bill to the president, the bill fails to become a law. This method is known as the pocket veto, for by simply withholding a bill presented to the parliament president during the last few days of the session of Congress, the president can prevent the bill to become a law. In India, the veto of the Indian president is a combination of the absolute, suspensive and pocket vetoes. Thus, as in England, there would be an end to a bill if President declares that he withholds his assent from it. Though such refusal has become obsolete in England since the growth of the cabinet system, under which it is the cabinet itself which is to initiate the legislation as well as advise a veto. Such a provision was made in the Government of India Act 1935. Even with the introduction of full ministerial responsibility, the same provision has been incorporated in the Constitution of India. Normally, this power will be exercised only in the case of private member's bill. In the case of a government bill, a situation may, however, be imagined where after the passage of a bill and before it is assented to by the president, the ministry resigns and next council of ministers commanding a majority in the parliament advises the president to use his veto power against the bill. In such a contingency, it would be constitutional on the part of the president to use his veto power even though the bill had been duly passed by the parliament. If, however, instead of refusing his assent outright, the president remits the bill or any portion of it for reconsideration, a passage of the bill by an ordinary majority would compel the president to give his assent. This power of the Indian president thus differs from the qualified veto in the United States insofar as no extraordinary majority is required to effect the enactment of the returned bill. The effect of a return by the Indian president, it's thus merely suspensive. As has been stated earlier, this power is not available in the case of money bills. Another point is to be noted is that Constitution does not prescribe any time limit within which the president is to declare his assent or refusal or to return the bill. Article 111 simply says that if the president wants to return the bill, he shall do it as soon as possible. After the bill is presented to him, by reason of this absence of a time limit, it seems that the Indian president would be able to exercise something like a pocket veto by simply keeping the bill on his desk for an indefinite time, particularly if he finds that the ministry is shaky and is likely to collapse shortly. This disallowance of state legislation. Besides the power to veto union legislation, the President of India shall also have the power of disallowance or return for reconsideration of a bill of the state legislature, which may have been reserved for his consideration by the governor of the state, Article 201. reservation of a state bill for the assent of the President is a discretionary power of the governor of a state. In the case of any bill presented to the governor for his assent after it has been passed by both houses of legislature of the state, the governor may, instead of giving his assent or withholding his assent, reserve the bill for the consideration of the President. In one case, reservation is compulsory, which where the law is in question would derogate from the powers of High Court under the Constitution, Article 202 proviso. In the case of money bill so reserved, the President may either declare his assent or withhold his assent. But in the case of bill other than a money bill, the President may, instead of declaring his assent or refusing it, direct the governor to return the bill to the legislature for reconsideration. In this latter case, the legislature must reconsider the bill within 6 months, and if it is passed again, the bill shall be presented to the President again, but it shall not be obligatory upon the President to give his assent to this case too. Article 201. It is clear that a bill which is reserved for the consideration of the President shall have no legal effect until the President declares his assent to it, but no time limit is imposed by the Constitution upon the President either to declare his assent or that he withholds his assent. As a result, it would be open to the President to keep a bill of the state legislature pending at his hands for an indefinite period of time without expressing his mind. In a strictly federal constitution like that of the United States, the states are autonomous within their sphere, and so there is no scope for the federal executive to veto measures passed by the state legislatures. Thus, in the Constitution of Australia too, there is no provision for reservation of a state bill for the assent of the Governor General, and the latter has no power to disallow state legislation. But India has adopted a federation of the Canadian type. Under the Canadian Constitution, the Governor General has the power not only of refusing his assent to a provincial legislation which has been reserved by the governor for the signification of the Governor General's assent, but also of directly disallowing a provincial act. Even where it has been reserved by the governor for his assent, these powers thus give Canadian Governor General a control over provincial legislation, which is unknown in the United States of America or Australia. This power has in fact been exercised by the Canadian Governor General not only on the ground of encroachment upon dominion powers, but also on grounds of policy, such as injustice, interference with the freedom of criticism, and the like. The provincial legislature is to this extent subordinate to the Dominion executive. There is no provision in the Constitution of India for a direct disallowance of state legislation by Union President, but there is provision for disallowance of such bills as are reserved by the state governor for assent of the President. The President may also direct the governor to return the bill to the state legislature for reconsideration. If the legislature again passes the bill by an ordinary majority, the bill shall be presented again to the President for his reconsideration. But if he refuses his assent again, the bill fails. In short, there is no means of overriding the President's veto in the case of state legislation. So the Union's control over state legislation shall be absolute, and no grounds are limited by the Constitution upon which President shall be entitled to refuse his assent. As to reservation by the Governor, it is to be remembered that the Governor is a nominee of the President, so the power of direct disallowance will be virtually available to the President through the Governor. These powers of the President in relation to state legislation will thus serve one of the bonds of central control in a federation tending towards the unitary type, the ordinance making power. The President shall have the power to legislate by ordinances at a time when it is not possible to have a parliamentary enactment on the subject immediately. Article 123. The ambit of this ordinance making power of the President is to co-extensive with the legislative powers of Parliament, that is to say, it may relate to any subject in respect of which Parliament has the right to legislate and is subject to the same constitutional limitations as legislation by Parliament. Thus, an ordinance cannot contravene the fundamental rights or any more than an act of Parliament. In fact, Article 13(3)(a) doubly ensures this position by laying down that law includes an ordinance. Subject to this limitation, the ordinance may be of any nature as parliamentary legislation may take. As for example, it may be retrospective or may amend or repeal any law or act of Parliament itself. Of course, an ordinance shall be of temporary duration. This independent power of the executive to legislate by ordinance and is a relic of the Government of India Act 1935. But the provisions of the Constitution differ from that of the Act of 1935 in several material respects as follows. Firstly, this power is to be exercised by the President on the advice of his Council of Ministers and not in the exercise of his individual judgment, as the Governor General was empowered to act under the Government of India Act 1935. Secondly, the ordinance must be laid before Parliament when it reassembles and shall automatically cease to have effect at the expiration of 6 weeks from the date of reassembly unless disapproved earlier by Parliament. In other words, an ordinance can exist at the most only for 6 weeks from the date of reassembly if the Houses are summoned to reassemble on different dates, and period of 6 weeks is to be counted from the later of those dates. Thirdly, the ordinance making power will be available to the President only when either of the two houses of Parliament has been prorogued or is otherwise not in session, so that it is not possible to have a law enacted by Parliament. He shall have no such power while both houses of Parliament are in session. The President's ordinance making power under the Constitution is thus not a coordinate or parallel power of legislation available while the legislature is capable of legislating. Any legislative power of executive independent of the legislature is unimaginable in the USA, owing to the doctrine of separation of powers underlying the American Constitution, and even in England, since the case of proclamations 1610 to St. TR 723, but the power to make ordinance during recess of Parliament has been justified in India on the ground that President should have the power to meet with a pressing need for the legislation when either house is not in session. It is not difficult to imagine cases where the powers conferred by the ordinary law existing at any particular moment may be difficult to deal with a situation which may suddenly and immediately arise. The executive must have the power to issue an ordinance, as the executive cannot deal with the situation by resorting to the ordinary process of law because the legislature is not in session. Even though the legislature is not in session, the President cannot promulgate an ordinance unless he is satisfied that there are circumstances which render it necessary for him to take immediate action. Clause 1 of Article 123 says, it is if at any time except when both houses of parliament are in session, the president is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear to him to require. But immediate action has no necessary connection with an emergency such as is referred in Article 352. Hence, the promulgation of an ordinance is not dependent upon the existence of an armed rebellion or external aggression. The only test is whether the circumstances which call for the legislation are so serious and imminent that the delay involved in summoning the legislature and getting the measure passed in the ordinary course of legislation cannot be tolerated. But the sole judge of the question whether such a situation has arisen in the President himself, and it was held in some earlier cases, a court cannot inquire into the propriety of his satisfaction, even where it is alleged that the power was not exercised in good faith. But if on the expiry of an ordinance it is promulgated, and this is done repeatedly, then it is an abuse of the power and a fraud on the Constitution. In Cooper's case, however, the Supreme Court expressed the view that the genuineness of the President's satisfaction could possibly be challenged in a court of law on the ground that it is malified, as for example, where the President has prorogued a House of Parliament in order to make an ordinance relating to a controversial matter so as to bypass the verdict of the legislature. The Indira government wanted to silence any such judicial interference in the matter of making an ordinance by inserting clause 4 in Article 123, laying down that the President's satisfaction shall be final and could not be questioned in any court or on any ground. The Janata government overturned the foregoing change. The net result is that the observation in Cooper's case re-enters the field, and the door for judicial interference in a case of malafides is reopened. To establish malafides may not be an easy affair, but the revival of Cooper's observation may serve as a potential check on any arbitrary power to prorogue the House of Parliament in order to legislate by ordinance. It is true that when the ordinance making power is to be exercised on the advice of a ministry which commands a majority in Parliament, it makes little difference that the government seeks to legislate by an ordinance instead of by an act of Parliament, because the majority would have ensured a safe passage of the measure through Parliament even if a bill had been brought instead of promulgating the ordinance. But the argument would not hold good where the government of the day did not carry an overwhelming majority. Article 123 would in such a situation enable the government to enact a measure for a temporary period by an ordinance, not being sure of support in Parliament if a bill has been brought, even where the government has a clear majority in Parliament. A debate in Parliament which takes place where a bill is introduced not only gives a nationwide publicity to the pros and cons of the measure, but also gives to the two houses a chance of making amendments to rectify unwelcome features or defects as may be revealed by the debate. All this would be absent where the government elects or legislate by ordinance. It is evident, therefore, that there is a likelihood of power being abused even though it is exercisable on the advice of the Council of Ministers, because the ministers themselves might be tempted to resort to an ordinance simply to avoid a debate in Parliament, and may advise the President to prorogue Parliament at any time, having this specific object in mind. It is clear that there should be some safeguard against such abuse. So far as the merits of the ordinance are concerned, Parliament of course gets a chance to review the measure when government seeks to introduce a bill to replace it. It may also pass resolutions disapproving of the ordinance if and when the government is obliged to summon the Parliament for other purposes, Article 123(2)(a). But the real question is how to enable Parliament to tell the government, short of passing a vote of censure or of non-confidence, that it does not approve of the conduct of the government in making the ordinance instead of bringing a bill for the purpose. The House of the People has made a rule requiring that whenever the government seeks to replace an ordinance by a bill, a statement explaining the circumstances which necessitated immediate legislation by ordinance must accompany such bill. The statement merely informs the House of the grounds advanced by the government. A general discussion takes place on the resolution approving the ordinance, and generally a resolution is moved by the opposition disapproving the ordinance. The pardoning power. Almost all constitutions confer upon the head of the executive the power of granting pardons to persons who have been tried and convicted of some offense. The object of conferring this judicial power upon the executive is to correct possible judicial errors, for no human system of judicial administration can be free from imperfections. In Kehar Singh's case, the following principles were laid down. The convict seeking relief has no right to insist on oral hearing. No guideline need to be laid down by the Supreme Court for the exercise of the power. C. The power is to be exercised by the President on the advice of the central government. The President can go into the merits of the case and take a different view. Exercise of powers by the President is not open to judicial review, except to the limited extent as indicated in Maru Ram's case. The court can interfere only where the presidential decision is wholly irrelevant to the object of Article 72 or is irrational, arbitrary, discriminatory or malified. It should be noted that what has been referred to above as the pardoning powers comprises a group of analogous powers, each of which has a distinct significance and distinct legal consequences, which pardon, reprieve, respite, remission, suspension, commutation. Thus, while a pardon rescinds both the sentence and the conviction and absolves the offender from all punishment and disqualifications, commutation merely substitutes one form of punishment of another of a lighter character. As for example, each of the following sentences may be commuted for the sentence next following it: death, rigorous imprisonment, simple imprisonment, fine. Remission, on the other hand, reduces the amount of sentence without changing its character. As for example, a sentence of imprisonment for 1 year may be remitted to 6 months. Respite means awarding a lesser sentence instead of a penalty prescribed in view of some special facts. As for example, the pregnancy of woman offender. Reprieve means a stay of execution of a sentence. As for example, pending a proceeding for pardon or commutation. Pardoning power of President and Governor compared. Under the Indian Constitution, the pardoning power shall be possessed by the President as well as the state governors under Article 72 and 161 respectively, as follows. President has the power to grant pardon, reprieve, respite, suspension, remission, or commutation in respect of punishment or sentence by court martial. Governor has no such power. Where the punishment or sentence is for an offence against a law relating to a matter to which executive power of the Union extends power similar to those of President in respect of an offence against a law relating to a matter to which the executive power of the state extends, except as to death sentence, for which see below. In all cases where the sentence is one of death, no power to pardon governor has no power to pardon in case of sentence of death, but the power to suspend, remit, or commute a sentence of death if conferred by law remains unaffected. In the result, President shall have the pardoning power in respect of all cases of punishment by court martial. The governor shall have no power. Offences against laws made under the Union and concurrent lists as regards law in the concurrent sphere, the jurisdiction of President shall be concurrent with that of the Governor. Separate provision has been made as regards sentence of death. The only authority for pardoning a sentence of death is the President. But though the Governor has no power to pardon the sentence of death, he has under Section 54 of Indian Penal Code and sections 423, 433 of Criminal Procedure Code 1973 the power to suspend, remit, commute a sentence of death in certain circumstances. This power is left intact by the Constitution, so that as regards suspension, remission, and commutation, the Governor shall have a concurrent jurisdiction with the President. Miscellaneous power. As the head of the executive power, the President has been vested by the Constitution with certain powers which may be said to be residuary in nature and are to be found scattered amongst numerous provisions of the Constitution. Thus, the President has the constitutional authority to make rules and regulations relating to various matters, such as how his orders and instruments shall be authenticated, the paying into custody of and withdrawal of money from the public accounts of India, the number of members of Union Public Service Commission, their tenure and conditions of service, recruitment and conditions of service of persons serving the Union and the secretarial staff of Parliament, the prohibition of simultaneous membership of Parliament of the legislature of a state, the procedure relating to the joint sitting of the Houses of Parliament in consultation with the chairman of the speakers of the two houses, the manner of enforcing the orders of Supreme Court, the allocation among states of emoluments payable to a governor appointed for two or more states, the discharge of the function of a specifying scheduled caste and scheduled tribes, specifying matters on which it shall not be necessary for the government of India to consult the Union Public Service Commission. He has the power to give instructions to governor to promulgate an ordinance if a bill containing the same provision requires the previous sanction of the President under the Constitution, Article 213, 1 proviso. He has the power to refer any question of public importance for the opinion of the Supreme Court, and already 10 such references have been made since 1950, Article 143, see Chapter 22 under advisory jurisdiction. He has the power to appoint certain commissions for the purpose of reporting on specific matters, such as commission to report on the administration of scheduled areas and welfare of scheduled tribes and backward classes, the Finance Commission, Commission on Official Language, or Interstate Council. He has some special powers relating to Union territories or territories which are directly administered by the Union. Not only is the administration of such territories to be carried on by the President through an administrator responsible to the President alone, but the President has the final legislative power to make regulations relating to the Andaman and Nicobar Islands, the Lakshadweep, Dadra and Nagar Haveli, and may even repeal or amend any law made by the Parliament as may be applicable to such territories. Article 240. The President shall have certain special powers in respect of the administration of scheduled areas and tribes, scheduled area and tribes, the tribal area in Assam, subject to amendments by Parliament. To the President shall have the power by order to declare an area to be scheduled area or declare that an area shall cease to be a scheduled area after the boundaries of scheduled areas and the like. Fifth schedule, para 6. A tribes council may be established by the direction of the President in any state having scheduled area and also in states having scheduled tribes therein but not scheduled areas. Fifth schedule, para 4. All regulations made by the governor of a state for the peace and good government of the scheduled areas of the state must be submitted forthwith to the President, and until assented to by him, such regulations shall have no effect. Fifth schedule, para 5.4. The President may at any time require the governor of a state to make a report regarding the administration of scheduled area in that state and give directions as to the administration of such areas. Schedule 5, para 3. The President has certain special powers and responsibilities as regards scheduled castes and scheduled tribes, subject to modification by Parliament. The President has the power to draw up and notify the list of scheduled castes and scheduled tribes in each state and union territory. Consultation with the governor is required in the case of the list relating to a state. Article 341 to 342. The President shall appoint a special officer to investigate and report on the working of the safeguards provided in the Constitution for the scheduled caste and scheduled tribes. Article 338. The President may at any time shall be at the expiration of 10 years from the commencement of the Constitution appoint a commission for the welfare of scheduled tribes in states. Article 339. Emergency powers. The foregoing may be said to be an account of the President's normal powers. Besides these, he shall have certain extraordinary powers to deal with emergencies which deserve a separate treatment. Chapter 28 post. For the present, it may be mentioned that the situation that would give rise to these extraordinary powers of the President are of three kinds. Firstly, the President is given the power to make a proclamation of emergency on the ground of threat to the security of India or any part thereof by war, external aggression or armed rebellion. The subject of this proclamation is to maintain the security of India, and its effect is inter alia assumption of wider control by the Union over the affairs of the states or any of them as may be affected by armed rebellion or external aggression. Secondly, the President is empowered to make proclamation that the government of the state cannot be carried on in accordance with the provisions of the Constitution. The breakdown of the constitutional machinery may take place either as a result of a political deadlock or the failure by the state to carry out the direction of the Union. Article 356, 365. By means of the proclamation of this kind, the President may assume to himself any of the governmental powers of the state and the Parliament to powers of the legislature of the state. Thirdly, the President is empowered to declare that a situation has arisen whereby the financial stability or credit of India or of any part thereof is threatened. Article 360. The object of such proclamation is to maintain the financial stability of India by controlling the expenditure of the states and by reducing the salaries of the public servants and by giving directions to the state to observe canons of financial propriety as may be necessary. This is all about today's part of the Union Executive in the series of our Constitution. Thanks, regards.